We're going to do our best to make sure that you understand the FTC ban in this short time that we have together today. If you're not familiar with the FTC ban, is taking effect on September 4th. There are some cases that are challenging the ban, but the Federal Trade Commission, which monitors trade, is going to implement this non-competition clause. It applies to both employees and independent contractors. There's some argument, as I've written about, extending it to independent contractors. I'll explain a little bit more of that in a moment. What you need to know is I'm not going to be giving you any legal advice on this webinar. I'm just going to give you that general overview. I know some of you are in other states beyond New York. So what I will do is give you enough information to hopefully identify what you might need to know to take to an expert in your state or in your state. Just because I'm a lawyer doesn't mean I'm your lawyer because you came on a webinar. If you need me to connect you with someone that can help you, then I'll be happy to do that. One other thing I just want to remind you, you're being recorded. If you do have a question, then you can raise your hand using the raise hand function on the lower section of your screen, depending on if you're on Zoom on a laptop or if you're on your phone, it might be in a different place. If you do have something to share or you want to ask a question, then don't disclose who might be involved, even if it's you. We like to say something in a hypothetical format. What would happen if an employer does blank? Is it okay if someone does X? Could an employee remember that I didn't make the law? I'm just relaying information on it. I'll do my best to guide you. What you need to know now is, again, the ban takes effect on September 4th. The legal challenges in Texas will not affect New York employers, and you will need to give notice to all workers currently restricted by a non-competition agreement if the ban does take effect on September 4th, as we expect it to. That's a big one that a lot of people don't realize. If you're an employer and you've been using non-competition clauses, you better find out who needs to be given notice, because they can penalize you up to $10,000 per occurrence. If you're an employee, you may find that you're going to get various notices from employers that you might have left and they may have had you at the time of your separation sign that non-competition clause. So frequently asked questions that I get are, does the ban apply to all employers regardless of size? The answer is yes. How can employers protect their client list? This is a big one that I get a lot lately. Well, now that we can't use non-compete clauses, how do we protect our intellectual property and our client list, other trade secrets? You can still use confidentiality, non-disclosure, and non-solicitation agreements. The reason I think a lot of people get confused about that is we refer to those agreements that have all those clauses as NDAs, non-disclosure agreements. And that's just one provision in a lot of them. Very rarely do I see an NDA that only has a non-disclosure agreement. It usually has the confidentiality, the non-solicitation, and the non-competition or non-compete agreement. But you can still use everything except the non-compete. Does the ban apply to independent contractor agreements too? And like I said, it depends. What it really depends on is whether the independent contractor is a true independent business with more than one contract, more than one client for the services that it provides. If you were on the invitation on LinkedIn, you probably saw some discussion around this very issue. How can employers get into trouble? There can be that $10,000 fine per individual not notified. You as the employer, if you have non-competition clauses that certain workers are still bound to, then you will be required to give them notice that you will not enforce that non-competition clause. Other ways that employers can get in trouble, even if they give notice, they might not end up giving notice to all the workers that they're required to. So I'm anticipating that there are going to be more audits that reveal misclassification of employees as independent contractors. That means, again, that someone's calling a worker an independent contractor who doesn't actually have an independent business. The quote employer is their only client. That client starts to dictate how the work is done, determines the pay, maybe posts a job to find that quote independent contractor. If that independent contractor is being paid and then issued a 1099 at the end of the year with their social security number instead of a tax identification number or an employer identification number, those are usually big red flags for me to look a little deeper and make sure that those are true independent businesses. Because if they are not, and some of these workers that you've called independent contractors are subject to, for example, a non-competition clause, and they're actually employees, then there's no question that the non-competition clause is going to be banned by the FTC. Then employers are going to potentially get into trouble for the additional penalties and interest if they've misclassified workers, because then there is the failure to withhold and submit payroll taxes, failure to secure workers' compensation, disability, and paid family leave insurance. This is specifically in New York, but other states tend to have some sort of program like this. I believe all of the states at this point require workers' compensation at least. And then you would have potentially the paid family leave or some version of that, paid safe and sick leave. You might be required to conduct mandatory trainings, and you definitely would be required to post mandatory notices. The notices that we always had, like in our break rooms or other places where employees gather, we now are also required to give electronic notice of those. The penalties are starting to add up there, and I am getting more calls from clients who are getting audited about that. Hopefully what you're hearing from this is you better start getting in compliance, and if you're not sure you are, it would be much better for you to do a self-audit than to let the government do it for you, because they will fine you and those fines can get very costly. Some people are asking, well, why are we doing this now? What is this whole issue with the non-competition clause? A lot of it comes down to two basic premises. One, we want to make sure that people who want to work have the ability to work. And having a non-competition clause restrict them from working, especially in the industries that they're most skilled in, it's just not really for the benefit of all of society. It's more for the benefit of one employer who's trying to keep all the other competitors from being viable. And again, it's the Federal Trade Commission that has implemented this ban. They are charged with regulating interstate commerce. We want to make sure that our economy is healthy. And how do we do that? By making it easier for employers and businesses to innovate. One of the ways they innovate is by moving talent into new positions in their organization. Having those lateral moves between companies tends to cause a lot of innovation. There was an opportunity to comment on the FTC ban before it was actually passed. And overwhelmingly, the comments seemed to support the ban, including from business owners, because business owners also want to be able to attract top talent so that they can compete. I want to tell you a little bit about a case that I worked on recently. It was a misclassified employee, basically, who came to me and said, I have this employment agreement that I want you to look at. I'm thinking of taking this job. Now, you already heard me say, and you can see on the screen, it says misclassified employee. It was very clear when I looked through the agreement that they had claimed this employee was going to be an independent contractor. The employee was required to use the employer's equipment, to work a certain number of hours, to have a certain degree of training, etc. And the employee was subject to a $100,000 penalty for competing if he left this potential employer. That is exactly why the FTC stepped in and said, this is ridiculous. Not only is it making it very difficult for employees to find gainful employment, but they're going to be penalized. It doesn't necessarily have to be quite so egregious for the FTC to be incentivized to implement this ban. If you registered in advance, I sent you my vendor intake sheet because I thought this was a really good way to have you look at anybody you are using if you're using independent contractors. Again, this is written for clients in New York, but it's very instructive also for those of you that are in other states. Go through the intake to make sure that the various elements that show an independent business are there. You'll notice on the form, it requests things like the name of the business, the EIN number or the TIN number. How are they formed? Are they an LLC, a corporation? You don't have to be an LLC or a corporation to be an independent business, but it sure is helpful if you are. There are sole proprietors as well. They may even be registered with a DBA, a doing business as. They have a trade name that they're using. Those are all elements to show that the independent contractor is truly an independent business. It's looking at other things too, social media accounts that are in a trade name. How are they holding themselves out on LinkedIn? Do they have a website? All the things that you would look for someone who's running an independent business. Notice I said it's a vendor intake sheet because independent contractor, vendor, pretty much the same thing. They might not be suppliers to the extent that they're supplying you with various materials, but they may be doing various projects for you. They could be doing ongoing work, but the more that it starts to look like employment, the more likely it is that the Department of Labor, the FTC, the National Labor Relations Board, and don't forget the Workers' Compensation Board will all start to look at it as employment, which means you've misclassified. And again, the FTC ban then clearly would apply to you as well as a lot of other employee protection laws. That's why I included that with this particular webinar. At this point, I'm going to open it up to questions. If anybody has questions, I'm happy to answer them. This is a Q&A.
Nancy, it's Deborah Hamilton. I work in the veterinary medicine industry with disagreements. Often, if you work for a corporate veterinary group and they have a non-compete, that non-compete could mean that you have to move out of state. What do you do in those cases?
Licensed professionals a lot of times will be deemed independent businesses, but not always. I would definitely go through that vendor intake form and look for the evidence of true independence. Look at things like who controls the work in a veterinary practice. A lot of times someone will come in and they will serve the clients or the pet owners for that particular practice. They're serving other people's clients. At that point, the more control that is exhibited over the independent contractor, the less independent they look, which means they might just be a roving employee. I would definitely look there to see if there are holes. Even if they're true independent contractors, technically, the FTC ban currently reads to apply to independent contractors. We're expecting, again, a lot of challenge on that because if you can show it's a true independent business, our argument would be that it's a business to business transaction that should not be subject to the FTC ban. Does that answer your question?
That answers part of my question. That would be good news for what we call relief vets who go from practice to practice to
Right.
stand in for a veterinarian who is on vacation or sick. But these corporate veterinary practices actually hire veterinarians as employees. They are employees who often either don't read the contract or they figure they can get out of it if they have to. The corporate veterinary practices often want to make sure you can't go anywhere to practice except with them.
The short answer to your question then is the ban will apply to those employees, which means any of the non-compete clauses that they're currently under will not apply after September 4th. And the corporate veterinary practice will be required to give those individuals notice that they will not enforce the non-compete clause. That's news to a lot of people. The FTC currently has the discretion to fine up to $10,000 per individual. It's exactly the situation that you're talking about, where the corporate veterinary practice understandably is trying to reduce the competition that they would have, but they are not going to be allowed to restrict people from working. Thank you for asking that question. Anybody else have questions?
Hi, Nancy. Thank you for the information, first of all. I'm just curious to know if this would apply to my business structure where I have had to insert in like a new independent contractor agreement with the help of an attorney, some language basically saying once you're hired and you're in a facility where you're teaching, you're not allowed to go and then offer your services, basically piggyback off client list. You're not allowed to go in and now offer your tap dancing class to this facility. Does this apply to that scenario?
It may very well apply. So you're talking about a couple of things. This is where I would go back to your attorney, because I do know that you're not in New York. And I would, if I were you, I would go back to your attorney and talk to them about this, because there are a couple of issues going on there. One, you've got your intellectual property. That is yours. You're allowed to restrict people from using that. You can also then restrict them from soliciting your clients, which is also something you're hinting at. You're still allowed to restrict any use of your intellectual property, which includes trade secrets, any kind of programs that you've developed, in your case, creative works. But then there is this gray area depending on if they're employees, true employees, or true independent contractors. If it's clear that they're employees, then you can't restrict them from working. But what you're describing is them offering a product or service, which sounds more like a business, and business to business transactions are still in that gray area where we're not sure how that one's going to play out. Generally, what we're anticipating is if you can show it's a true business to business transaction, that there would be a little bit more freedom for you to contract with another business because you're considered on equal footing. What the FTC, the Department of Labor, and the various government agencies tend to do is they look for the more vulnerable people. They're going to presume that an employee is more vulnerable than the business owner, and they try to balance the playing field. That's where some of this comes from. So if you're true business to business, there's a good chance that you'll still be able to use non-competition clauses. But if you can work around it and just focus on the intellectual property with confidentiality, non-disclosure, and non-solicitation, I would recommend that. But again, go back to your attorney and talk to them about that.
Excellent. Thank you.
You're welcome.
A lot of times I'm being asked to sign agreements that I reject that have a lot of language of anything that's done during the time you're working with us is now our intellectual property.
Right.
I'm seeing some just dramatic overreaches in that regards. And so I'm wondering if there's just some way we can kind of give them language, or if that's being covered at all with this.
You're talking about what we call works for hire. You're going in and you're working for someone else. You're being hired to perform those services and create those works. There usually is some sort of clause in agreements like that that will say, if we hire you and we pay you and you create something while you're there, we get to keep it. If it were a business to business, again, going in that equal footing kind of mentality, then you all probably negotiate. Definitely, I would recommend you talk to somebody in your jurisdictions where you're doing business and make sure that you're getting really good contracts formed. So that's dealt with up front. We do see a lot of litigation where there are works for hire. Somebody created something while they were working for someone, whether it's an employee or an independent contractor. If the contract is silent, you're going to end up in litigation, and it could go in any direction. It's much better to just be upfront and avoid court. I was just dealing with this earlier this morning. Something I tell people a lot, and you'll see I write about this on my blog pretty regularly too, is that when you're in the contract negotiation, there's a lot you can learn about each other during that process. I get that sometimes it looks like a great opportunity. It's a good deal of money at a time when we could use money. I totally understand that. But there's a lot you can learn in that negotiation. Remember that it is just like if you were going to a regular job interview, you're still in the process of feeling each other out to see if you're going to work together. And what goes into somebody's contract will tell you a lot about how they're going to be to work with. You might go back to them, ask them, what is it you're trying to achieve with this? If they don't give you an answer that you like, you might want to reconsider doing business with them, because if they have that bullying approach, it's been my experience that someone that's overly controlling with that agreement, they're going to be a nightmare to work with as well. Now, it's not always true, but it's something definitely to consider.
Yeah, exactly. And I have been in that situation and made that exact decision.
I will give the caveat of that is a lot of times you're working with someone who's maybe kind of new to the business, or they just have the process where maybe they do call their attorney and they get a very standard contract with a lot of language that's not necessary. But if you're working with someone and customizing that agreement, then there's a true meeting of the minds. And that's really what the contract is supposed to be. If you're not getting that, then you might get some help to negotiate something better, or again, reconsider working together. Be mindful of who you do business with, because it looks like good money up front, but if you end up in court and they challenge your payment, what good did it get you? I am doing free 15-minute consultations in relationship to this. Anything that you want to chat about, I'm happy to take that 15 minutes to get you moving to the next step with whatever you're working on. And if that means you need a resource like an attorney in your location, happy to help you. I really just want you to be successful. Thank you so much. Have a great day, everyone.